All right, so we've talked about the legislative branch, and then we talked about the executive branch. We are now going to talk about the judicial branch, right? And the U.S. Constitution gives the judiciary, the judicial branch, very little attention, right? And it really vests the power to shape and define the judicial branch to Congress. And one of the very first things that Congress does of our new nation is pass the Judiciary Act of 1789. And that creates a sort of three-level judiciary system with the Supreme Court, the appellate courts, and then the trial courts down below. And it looks like this. There's also some specialized courts that we can talk about in a moment. Our state courts here in Nevada and other states have a kind of similar system where it has a Supreme Court, an intermediate appellate court that are sometimes called circuit courts or court of appeals, and then district courts are also called trial courts. They're also called courts of general jurisdiction. And like the federal government, they have some specialized courts as well, such as family court or juvenile courts or small claims courts, right? And these 50 states, right, they're organized in a similar fashion, but they really deal with most of the court cases in our country, right? When you and I are going to go to court, it's most likely going to be a municipal court, like dealing with a traffic violation, or a district trial court. It's rarely going to be a federal court system unless you violate a federal law, right? And so the state courts deal with millions and millions of civil cases where you and I might be suing each other, suing a business, and millions, right, of criminal cases, far more than the U.S. federal court system does. And ironically, and I even wrote a book chapter about this, political scientists tend to neglect state courts even though they have a much more profound effect on our lives than the federal courts do. Political scientists tend to focus a lot on the federal courts, especially the U.S. Supreme Court. And part of it is that they're more sexy because the U.S. Supreme Court often deals with issues related to the Bill of Rights. And that is very, very important. And it does trickle down to all individuals and our rights. So I don't want to downplay the federal court system, but on a day-to-day basis, the state courts interact with far more individuals than the federal courts do. And so just like any other state system, the Nevada judiciary operates independently, and their decisions cannot be appealed to the federal level unless it deals with the federal law or a violation of the Bill of Rights. So if you were charged with cocaine possession, but you felt that your Fourth Amendment rights were violated because it was an unreasonable or illegal search of your person or your property, you could then appeal to the federal level because that is a Fourth Amendment Bill of Rights issue, right? And so we have four levels where we have the Supreme Court, Court of Appeals, and the trial district courts, but we also have the specialized courts like judicial and municipal courts as well, right? We actually recently created our intermediate Court of Appeals, right? We tried to, for a number of years, to create the Court of Appeals because our Nevada State Supreme Court was the most overworked Supreme Court in the country, because it had to hear every appeal, right? Well, all appeals were directed to the Supreme Court. There was no intermediate court, right? And that meant that people were appealing their driver's license being revoked. Or they were, appealing something more serious like a murder conviction. All these appeals went to the Supreme Court of our state, and they were the most overworked state Supreme Court of all 50 states and the federal government. Finally, in 2014, we created an appellate court. And so the Supreme Court can assign cases to this Court of Appeals, and that can really help alleviate the burden. And really, it really delayed appeals. And there's an old saying, justice denied, right? Justice delayed is justice denied, right? And we had such a long waiting period between appeals. And so it was such a great thing that we created, like many other states and like the federal government, an intermediate appellate court. Here is a picture of the 7 justices that make up our Nevada State Supreme Court. They're elected. They're elected to 6-year staggered terms, sort of like the U.S. Senate, right? They're elected via nonpartisan elections. Unlike all the other elected positions in Nevada, there are no term limits on these judges, right? There's a minimum age qualification of 25, which at my age seems a bit young. And I think the state legislature agreed here in Nevada because they also added in 2005 a requirement of 15 years of legal experience, right? And we've increased the court's membership. Originally, it was 3 in our Nevada Constitution. It's been increased to 7. Now, political scientists are not thrilled about electing judges, and they're definitely not thrilled with electing judges through nonpartisan elections. I know it sounds like a great idea, right? That like, yeah, we should elect our judges, and shouldn't those elections be nonpartisan? What you find is that you have very non-competitive elections, and the worst type of election is a non-competitive election, right? With partisan elections, you tend to have competitive elections where you have 2 quality candidates that are competing for voters, right? We don't have that here in Nevada. In many cases, voters just leave it blank, right? Or they vote for none of the above candidates because they don't know who these judges are or what they represent or what their policy preferences are. And in most cases, judges run unopposed, right? And most judges just win re-election. It's really not working the way you think it is. And so I think a lot of political scientists would say, hey, you should be like North Carolina and change from nonpartisan to partisan elections, or be like other states or the federal government, let the governor and the state legislature nominate and approve of judges for the state Supreme Court. Because even if we got rid of electing judges, we would still have a way to remove judges right here in Nevada. We can recall them through voters, with the recall petition. Our state legislature can impeach them if they've done something improper or some type of, high crimes and misdemeanors, right? Or even if there wasn't a serious violation or crime, we have the power in our state legislature for a legislative removal for any reasonable cause, right? Just by a majority in both houses. And in the 70s, we created a commission, the Nevada Commission on Judicial Discipline, that can remove judges. So if you're afraid that if we got rid of electing judges that there wouldn't be some type of accountability, there would be. So let's move back to the federal court system, right? Where you have the 3 levels, Supreme Court, Appellate Court, and District Courts, along with the specialized courts. Here, I'm only going to mention the specialized courts very briefly. I know very little. They get very little attention. I was listening to NPR a while ago, and they talked about the Court of International Trade, and my ears perked up because I rarely hear about this. And I always admit to my students, I know very little about the specialized courts of our federal court system. And here's a really great story, because I like it, because I like Marvel and I like X-Men, about a debate whether an X-Men action figure being imported and sold in the United States is a toy or a doll, right? And so it's a great little NPR story. It's a Radiolab story that appears on the NPR radio station a number of years ago. So you can click on it. You can ignore this, or if you're interested in trade policy or X-Men or toys, you can click on it. I found it fascinating. So let's talk about the first level of the federal court system. If you're going to go to trial, right, it's going to be at a district court, and it's going to be one of the 94 districts, right? And so these 94 district courts are spread across the country and the different territories of the United States. And if you go to trial, you're going to see one judge and you're going to see a jury if you decide to have a jury. And the number of jury usually ranges between 6 and 12. You have the right to waive a right to a jury. You might do that because you think it's going to speed the process up, or you think the judge is going to be more lenient, right, or more understanding than a jury of your peers. That might be true, let's say, if you're a young black male and you think that the jury is going to be mostly perhaps white, right? And so you might be given advice by your lawyer to waive your right to a jury. right? And I'm not going to go through all of these, but the federal courts deal with issues involving federal laws or issues regarding the U.S. Constitution, or if two states are suing each other, right? Or an individual is suing another state that they don't live in, right? And so there are a variety of original jurisdiction cases that will go to the federal district courts, right? And I'm not going to go through all these. You can take a look at these. For example, immigration, right? If you appeal an immigration decision, immigration is a federal law. So of course that is going to go to the federal district courts, right? If you're going to sue a federal agency, that's going to go to federal district court. If you're unhappy with the decision at the district trial court, you can appeal to the appellate courts, or also known as the circuit courts. 90% are never appealed because court cases are long, slow, and expensive, right? You have to hire an attorney. But if you do appeal, it goes to a circuit court with 3 judges, not one judge, and no jury. And you don't bring in any new evidence. There's no cross-examination. Really, the appellate court is looking to see if there were any mistakes made in the district trial court. Were there mistakes made by the judge of the district court, right? Was there some violations? If so, then there may be a reason to overturn that decision, right? But really, no new evidence, no cross-examination, no jury, and it's just decided by 3 voting judges to decide whether to keep the decision of the lower court or overturn it. And of course, you could then appeal to the U.S. Supreme Court, right? We'll talk about that in a moment. These circuit courts are divided up. There's 13 of them into 13 different areas, 12 geographic areas, and then the 13th circuit court is a specialized court dealing with patents and copyrights and international commerce. Here's a map of the 12 geographic districts of the appellate courts. We're in District 9, which tends to be a bit more liberal, have liberal judges on them, because there is a norm that when there is a vacancy for the appellate courts, senators from these states make a recommendation. They're not always listened to, but often those recommendations are respected. And since you have Nevada, California, Oregon, and Washington, those state senators tend to be a bit more liberal. They might recommend more liberal judges, right? So the 9th Circuit Court tends to be a bit more liberal than, let's say, the 11th Circuit Court, which has Alabama, Georgia, and Florida, right? Let's talk about the Court of Last Resorts, Level 3, right? The Supreme Court is the only court that's specifically specified or mentioned in the U.S. Constitution. It is the Judiciary Act that sets the number, which set the number of the U.S. Supreme Court to 6, but has changed now to 9 members. And the Judiciary Act, as we mentioned earlier, created the Supreme Court, Appellate Court, and District Court system that we are so familiar with at the federal and even at the state level. And these appointments to the Supreme Court, the Court of Last Resort, are critical, right? Richard Nixon said it's the most important appointment that presidents make. And Dwight D. Eisenhower, who appointed a judge he thought was going to be more conservative, ended up being very liberal, Justice Earl Warren. He said it was the biggest damn fool mistake he ever made, right? And so really, you have people that really focus on this, and they'll even say, you know what, I don't like Donald Trump, but I'm going to vote for him because I know that he's going to appoint more conservative judges. Or someone might say, you know what, I really don't like Joe Biden. He's so boring, right? But I'm going to vote for him because I know in the end there are vacancies and Joe Biden will nominate more liberal judges, right? And so really this becomes a voting issue. Why you select a particular candidate, not just because you like someone's hair, you care about appointments to federal courts and the U.S. Supreme Court. Because remember, the president is the one that nominates all federal judges at all 3 levels: Supreme Court, Appellate Court, and District Courts. And relatively recently, we had Justice Kennedy, who was a little bit more of a centrist judge, leaning maybe conservative. Justice Kennedy retiring, And the backstory that I've heard, I have to double check this, was that Justice Kennedy really liked someone who had clerked for him back in the day, and that person was Brett Kavanaugh. And he recommended to Donald Trump, strongly recommended to Donald Trump, is what I've heard, that he nominate Brett Kavanaugh, even though Brett Kavanaugh was not on a list of 50 people that certain conservative interest groups had recommended that were judges that were very qualified but also conservative. Trump, for a variety of reasons, ignored the list and picked Brett Kavanaugh. I think partly because of Justice Kennedy. And then Brett Kavanaugh goes before the Senate Judiciary Committee and has to answer a bunch of questions, and a lot of very personal questions in it. And someone came out and accused him of, when he was, I think, 15 years old. I'd have to double check my facts there. But when he was in high school, that he had engaged in some type of sexual assault on another 15-year-old person. And again, because it happened so long ago, the FBI did open up a case and talk to people. And of course, there wasn't enough evidence. And the Republican majority on the committee and the Republican majority in the Senate voted to confirm Brett Kavanaugh. And again, even though I am not happy with the nominee, I feel that the system worked, and I'm smart enough and I engage in critical thinking enough that just because I'm unhappy with an outcome doesn't mean that the system didn't work, right? It'd be sort of like, wait, I got a bad grade in this class, the system must, and I'm unhappy with it, the system didn't work, right? It's possible maybe I really, excuse my language, screwed you and discriminated against you, and that's possible that the system didn't work and you got a grade that you didn't deserve, right? But it's also possible that you got the grade that you deserve, but because you didn't work hard enough and the system did work, you're just unhappy. I'm unhappy with this outcome. I believe that the system did work. So the Supreme Court, right, when it operates, it only needs 4 of the 9 judges to vote to hear a case, right? And really very few of the cases that are appealed, right, to the Supreme Court are heard, only about 1%. And these 4 justices that decide to hear an interesting case, we call that the rule of 4. And they usually look at whether there's a major controversy. They don't really care whether there's just 2 people that hate each other and suing each other. They want an issue that deals with larger issues that are affecting, thousands or tens of thousands or millions of people, right? So issue like gay marriage, right? Or, the right to have an attorney, right? And so they care about controversy. You also have to have standing. You have to have been harmed by a particular law, right? You can't just say, hey, I don't like that law, and because I'm really smart and I know that that law is unconstitutional, I'm going to sue because I know that law is unconstitutional. You have to be harmed by that law in order to go before the court and say, I've been harmed by this law, and I feel that the law is unconstitutional, and therefore I'm looking for a remedy, right? And then there's another issue called mootness, which is kind of vague. Mootness is the idea that, can the courts alleviate the problem? If they can't, then it's out of the court's hands and out of their power. This is kind of complicated. One example I had read about was that a federal court judge had ruled that the abortion law that was eventually went to the Supreme Court, Roe versus Wade, that the woman, Roe, who was suing, that the issue was moot because she had now given birth to the child. She wanted an abortion. Texas law didn't allow her to have the abortion. She's suing saying that the law is unconstitutional, but she's now given birth because it's 9 months later. So the court can't do anything. Sorry. The U.S. Supreme Court, right, overruled that federal judge and said that would be kind of a weird interpretation of mootness. What if this person, Roe, wants to have another child or doesn't want to have another child and gets pregnant again? The law is still relevant, right? And so she has been she has been harmed, she has standing, and we feel that the issue is not moot, that it's ripe, and that we need to deal with this issue, right? So that's a complicated issue. If we look at the Supreme Court, there's 3 different ways that the Supreme Court can hear a case. There are some cases that directly go to the U.S. Supreme Court, and that can be cases involving where a state is involved or where a diplomat or ambassador is involved. 30% of the cases come from state courts where someone feels that a federal issue or a Bill of Rights issue has been violated and they can appeal a state law or a state case all the way to the Supreme Court. Or it could be an original federal law or federal constitutional issue that the federal courts have been dealing with at the lower issues that eventually go up from the trial to the appellate to the Supreme Court. Now, the one thing I want you to remember from this class is judicial review, because it's one of the most controversial issues in American politics, and it's one of the most important aspects of our understanding of checks and balances, right? Judicial review is never mentioned in the Constitution, but you did have founding fathers that wrote about the issue, either assuming that this was sort of applicable to the U.S. Constitution or it should be, right? Now, the problem is that our Constitution provides very little detail about the court powers. There's clearly some evidence that we want some types of separation of power and checks and balances. But there was no clear detail on how the courts would check the power of the executive legislative branch. This gets sort of fixed by a Supreme Court case called Marbury versus Madison in 1803. Remember, 1789 is when the Judiciary Act created and organized the court system. So in 1803, the court is still very young, right? And hasn't heard a lot of cases and doesn't really know its exact role, right? We're a new country with a new constitution and a new Supreme Court. So judicial review, the backstory is that John Adams loses the election. Thomas Jefferson becomes the new president. John Adams making some last-minute appointments to judicial positions, signs them and gets them sealed, right? But they don't get delivered, right? And they are found on the Secretary of State's desk, James Madison. James Madison is the Secretary of State of Thomas Jefferson. He asks Jefferson, what should I do with these, right? They're sort of officially, they're official appointment letters, right? That have gone through the appropriate process. What should I do with them? Thomas Jefferson and John Adams did not like each other. There are 2 competing parties. He said, burn them, destroy them. William Marbury, right, was one of these appointees. He was going to be appointed to a lifetime tenured judicial appointment. I think it was a Justice of the Peace appointment, but I'd have to double check on that. Marbury is very upset. Like, wait. John Adams told me that he, filled out the paperwork and got it sealed and had it, delivered, that I was going to be appointed to this judicial position. I want my position. And he sues the Secretary of State and orders him to give him his judicial position, right? He sues James Madison, and he petitions the court to order the Secretary of State to deliver this commission. And this is called a writ of mandamus, right? You order a writ of mandamus, you mandate James Madison to give this commission to William Marbury, right? So the court hears these arguments, and the court has this dilemma. The court didn't want to approve of Jefferson's defiance of burning and destroying these appointments, right? Even if he felt that they were being delivered after midnight or what have you, whatever the justification, it was not an appropriate act. The court didn't want to approve of Thomas Jefferson's, but they worried that if they ruled against Thomas Jefferson and his Secretary of State, that Jefferson would just ignore it, right? Because Jefferson, as president, he has the power of the sword, the military, to enforce laws. Congress has the power of the purse, right? They control the budget, right? Courts have no power. They have no police force. They just declare something. We declare that you did something wrong. the president could just ignore this, right? So this new Supreme Court, right, being led by Chief Justice Marshall, really didn't exactly know what to do. They found an ingenious way to get out of this rock, between this rock and a hard place. They ruled that the Judiciary Act of 1789, which gave the court the power of writ of mandamus to order officials to do something, that was unconstitutional. You can't do that, right? The argument was that you can't give the courts extra power or extra authority like a writ of mandamus by simple congressional action. If you want to give the courts more power and want to give them the power of writ of mandamus, you have to amend the Constitution, which is a very complicated process as we learned. So, by ruling that the part of the Judiciary Act was unconstitutional, Marbury versus Madison and the Supreme Court almost accidentally create the power of judicial review. They're declaring an act of Congress unconstitutional, and they don't have to listen to it, right? Even though this power is never mentioned in the Constitution. And so there's this really ironic process going on that by ruling Congress can't expand the authority of the courts give itself expanded authority by creating judicial review. Now again, judicial review had been discussed and written about by the Founding Fathers, and some people felt that the U.S. Constitution had already kind of implied that this exists. But it never specifies this, right? So in some cases, this is a broad interpretation of the U.S. Constitution. And ever since, the Supreme Court has acted as it has the capacity to rule executive branch, right, and legislative branch, and even state actions unconstitutional. Now, people worry about the Supreme Court being too powerful. Political scientists typically don't worry too much about that. One, the Supreme Court and the federal court systems themselves, although they have lifetime tenure and they're not elected, they really lack sort of democratic legitimacy, right? They have prestige and mystique with their black robes and stuff. So when the Supreme Court rules on something, many of us go, okay, those are some really smart people appointed by presidents, and they say that this is unconstitutional or this is constitutional. You and I typically say, okay, that's pretty important. But we also may be very willingly to disagree with them, right? And the Supreme Court knows this, and they're very careful when they're confronting elected officials and majority-made decisions, right? And the Supreme Court has very limited resources. They only hear 1% of the court cases, right? And really, these judges only have 2 or 3 clerks helping them out to deal with all the paperwork, all the appeals that are landing in the court, right? And these clerks only serve for less than a year, and then they go off and do better things, right? So they have very limited resources, and those resources are controlled by Congress, which can be expanded or cut off, right? And remember, courts are reactive. They can't just stand on a chair and say, we declare this action unconstitutional, or that action unconstitutional, or that law unconstitutional. They have to wait until you or I or someone else goes through the long court process, through the state process or the federal court system, to the appellate system, and appeal to the U.S. Supreme Court for them to decide on something, right? They have no power to say, oh, look what President Trump just did. That's unconstitutional. We better let him know. They keep their mouth shut, right? They just sit and wait. They look at the files that are sent to them. They choose about 1% of them, and it's only the cases that you and I bring to them where they can state their opinion, right? And again, they must rely on other branches to enforce their decisions. As Alexander Hamilton noted in the Federalist paper, the courts has neither the power of the sword nor the purse. Sorry about my typo there for power. And we talked about this earlier, right? The Supreme Court ruled that segregation in schools, right, was unconstitutional in 1954. The states did nothing. They did nothing. They just kept the school systems in the South segregated, right? It wasn't until Congress, right, passed the Civil Rights Act, right, 1964, that would start to defund schools, right, and withhold funding, that you started to see schools start to desegregate, right? And so if you say that the U.S. Supreme Court has too much power, I think you have to collect the evidence to back up that argument. I think there's a lot of evidence that suggests that perhaps maybe the Supreme Court doesn't have enough power to put a check on the president or Congress. There's a lot of political scientists that have written that, right? So if you're going to make the argument that the Supreme Court has too much power, I would like to see the evidence, right, to suggest that they have too much power in our political system, right? Clearly, an unelected body with lifetime tenure at the district, appellate, and Supreme Court is a vexing issue, right? Because we believe in electing people, and this is an unelected body, right? But again, we elect the president and we elect the Senate, right? I would also argue that these lifetime tenured judges have clear limits on their power. They're reactive. They have to wait till you and I bring an issue to them, right? And they have they have no enforcement mechanism, right? And the courts know this. And there's a lot of evidence that the courts are aware that they're faced with the delicate balance between enforcing the Constitution, right, as the majority of the judges see it, and deferring to elected officials, right, in legislative bodies, in Congress and in state legislatures. They're aware of this balance, and that puts a clear check on their power, right? But we do want the court system to be able to put a check on Congress and a check on the president, right? So we want to make sure that the courts don't have too much power, but we also want to make sure that they don't have too many limits on their judicial power. I know that was a lot of information, but really, the judicial branch is such a fascinating topic. Make sure you read that chapter, and make sure you read the chapter on the sagebrush state on the Nevada judiciary.